Good evening, everybody. When New York's lawmakers passed sweeping changes to the gun laws earlier this year, they did that saying that it complied with the Supreme Court ruling that overturned restrictions that had been in place for more than a century. Well, tonight we're digging into a federal judge's opinion that is calling into question whether or not New York followed the constitutionality of that Supreme Court ruling. A federal judge last night ruling that despite the challenge from a gun owner near Albany, the new restrictions on pistol permits and where people can carry guns would go into effect today. That led to news releases from the governor and the state attorney general, among others, praising the judge's decision. But that judge also said in the ruling that he couldn't strike down the law because of technicalities, but said that in future legal challenges, it's likely that the new law will be declared unconstitutional. A lot to unpack there. Here to help us get to the bottom of it and how we should understand this is local attorney and Two on Your Side legal analyst John Elmore. Great to have you back on, John. Thank you. So this was federal court. It was a judge's decision last night. The judge basically suggesting that the new gun law is in violation of the Supreme Court's ruling earlier this year. Walk us through the legal rationale and your reaction to that.
Certainly. Well, Judge Sotheby is out of Syracuse in the Northern District of New York. And he ruled that the petitioners in the case lack standing to challenge New York State's law. The actual petitioners in this case was a gun group out of a not-for-profit group out of the state of Virginia. And they filed an injunction wanting the New York State law to be stopped and found to be unconstitutional. Standing is something that is required in order to file a lawsuit. Standing means you have to be a person that is aggrieved, a person that has actual interest in it. Now, the person that you mentioned in Albany was a member of this group, but the group is a non-for-profit group, Gun Owners of America, which is based incorporated in Virginia. And so the judge, for technical reasons, say that you aren't the people that are aggrieved. You're a not-for-profit organization based in the state of Virginia, and you don't have standing to tell us how to interpret New York State law. Now, if that was filed by a New York State not-for-profit organization, which was done in the Supreme Court, in the 6-3 Bivens decision, which found the old New York State concealed carry law to be unconstitutional, that was brought by the New York State Rifle and Pistol Association. And they had standing. That is a not-for-profit organization based in New York State, which is made up under New York State laws and incorporated in the state and comprised of members that live in this state.
So, John, as you look at this case now, let's put the standing issue aside, right? If someone does have standing and this is able to go kind of to the merits, do you think that the judge, based on the reading of it, would find that what our legislature and governor, put into law and what took effect earlier today would be found to be unconstitutional? Well,
now this was a judge in the Northern District of New York. Carl Palladino has filed a similar lawsuit here in the Western District of New York. Now, the judge in the Western New York may follow that logic, and he may not, but that case is still pending.
What are some of the legal issues that are at play here? I mean, obviously, these new gun laws added some steps in order to get a pistol permit, right? But then also, as we're reporting in our other newscasts today, looked at places that are considered sensitive where, you can't have a concealed carry moving forward. What parts of the law and that lawmakers changed do you think are going to be looked at in terms of moving forward?
Sure. One area that Judge Sotheby had concerns with was the character. A gun can only be, a concealed permit has to be given to a person of good character. And he found that to be possibly unconstitutionally vague. He looked at the places where you can carry a gun. You cannot carry a gun, according to this law, in churches, in public parks, in schools, in places of businesses, unless the business has a sign that says that guns are permitted in this business establishment. And in his ruling, his opinion, that was unconstitutionally broad. So the character provision was one that he paid particular attention to, as well as the places, because the places, the way that it was described, almost makes it questionable where it is legal that you can carry a gun, because you couldn't, even private premises without a specific invitation, you were not allowed to carry a concealed weapon in private premises.
I've got about a minute left, John. I think a lot of people watching right now, we know, a lot of people are supportive of gun restrictions. A lot of people believe that this, it infringes on Second Amendment rights. How quickly do you think we're going to get clarity on whether or not the law that went into effect today is allowed to continue, from here on out, or if it's going to be ruled unconstitutional?
Well, I think it's going to be very interesting to see when Carl Palladino's lawsuit that he filed in this district, when there's a decision there, and how quickly the justices here in Buffalo, in the Western District of New York, act on that petition for an injunction.
John Elmore is a local attorney and kind enough to come into the studio. Always good to see you in person. Thanks for helping us understand this. I know, again, as we mentioned, people very split on this gun law, and certainly more to come. Thank you.
And thank you for having me.